Meet Sylvia Ho, a lawyer who's got the legal info that business people need to know.
Welcome, everyone. We are beginning our IP series. IP stands for Intellectual Property, and we have attorney Matt Patterson here from Optimal IP Strategies. Attorney Patterson is a patent attorney, and we work with attorney Patterson for our clients that are in need of filing and defending patents. So welcome, Matt.
Hi, Sylvia. Thanks for having me. Good to see you.
So I think that let's just begin at the beginning, because since we're beginning the series, let's just cover some very basic things that even though our clients are more sophisticated than someone who would just walk off the street and not understand what a patent is, maybe we could just start with a baseline. What is a patent, and what are the benefits of a patent?
Sure, that's a great place to start. So a patent is a right given to an inventor and it's given in the United States by the United States Patent and Trademark Office. And the right that's given is actually it can be found in the Constitution, Article 1 of the Constitution, and it's the right to exclude others from practicing your invention, right? If you will. So that's the rights that are bestowed by a patent. And there are three basic kinds of patents. There's a utility patent, which most people are familiar with, covers how things work. And there's design patents, and that covers the ornamental design of something. And then there's design patents that protect, plant patents that protect unique species of plants.
So, more often than not, I hear from clients who have design patents versus utility patents. Is one patent stronger than another? I think that there's a conception that if you have a design patent, you don't really have anything, and if you have a utility patent, well, that's worth having, and you can sell it for millions of dollars if somebody wanted to buy it.
Sure. And that goes to your earlier question about the benefits of patents. So, design patent protects the ornamental nature of something, right? Only the shape, the aesthetics of it. And a utility patent protects, an invention, a device, a process, a chemical, the utility of it. So, design patents are great for people who do ornamental designs, even gates or refrigerators or things like that can be protected by a design patent if you're just protecting the look. And what that does is it allows the patent holder to prevent other people from making things that look like their design. People spend a lot of money with designs. And so that you don't want people just to knock them off. And so there's benefit when a lot of your value is derived from the way your product looks. A lot of value is derived from having a design patent. Utility patent, if you could make the invention or device look different, substantially different, but perform the same function, a design patent wouldn't be very useful there. But if you had a utility patent that covered that invention, then you could stop somebody from making your invention no matter how it looked. So it really depends on the nature of your invention and where you derive your value on how you want to protect things. And there are some inventions that you actually can get a design patent and a utility patent. And we can talk about in later sessions because it gets complicated quick on how you can assert those patents, but they are quite different.
So that just made me think about like a hearing aid, right? Because hearing aid, we have these hearing aids that go through an ear, right? And we have hearing aids that fit right inside, right? Those are the kinds of things that are covered by patents. Is that
sure, absolutely.
Right? So suppose I make a hearing aid, and that hearing aid is just for comfort, and the comfort is what is the secret sauce that I want to protect. And well, first of all, this brings up a very, very important question, which is, who benefits? What is the best candidate for a patent? Because we just talked about a hearing aid, and we're going to sell it to people in the public or through an audiologist. So what is there a general rule as to this has got to be patented if you're going to market this product and benefit for it for a long time?
Sure. Yeah. So right. So who benefits the most from having a patent? How do you decide? So if your device, the secret sauce, if you will, can be found out after it's been released into the public by reverse engineering it, taking it apart, seeing how it works. If it can be copied, that's a good candidate for a patent, right? You want to prevent others from copying your invention. If they were to take it apart and it's, say, driven by software, right? That you can't, so it's the way that the hearing aid, it has a chip with software on it, and that's really what differentiates your invention from somebody else's. The software may not be worth patenting because nobody can, except from a functional standpoint, determine how that thing works, how the software makes that hearing aid work. So that may not be the best candidate for a patent. You may want to just keep that as a trade secret, and we can talk about that in another series. But so if it's easily discernible once it's released into the public, that's probably something you want to pursue patent protection for.
So this brings up another question, which is, and we can talk about this a lot, because in patents we've had this history of reverse engineering. I mean, there's these stories about going to another country, giving them the Parker pen, and then having them reduce it and then selling it back to us. So we're going to be talking about that later on in this series. But let's talk about the U.S. Patent and Trademark Office. Why is it important, and why do I have you on here? Why can't I go and sort of say, hey, I'll file a patent for you?
Sure. So the United States Patent and Trademark Office is physically located in Washington, D.C., and it administers its own bar exam to attorneys. And in order to sit and that passing that bar exam, attaining a license from the USPTO is what gets certain attorneys like myself into the Patent and Trademark Office. Without that, you can't, just a normal attorney barred in any state can't practice before the United States Patent and Trademark Office. And then in order to actually sit for that patent bar exam, you have to have be licensed in a state. So in my case, I'm licensed in the state of Connecticut, having passed the Connecticut bar exam, but you also have to have an undergraduate degree in applied science. So engineering, any science with a lab like biology, chemistry, those kinds of applied sciences. So somebody with a humanities degree, right, even though they have have gone to law school and passed the bar exam, can't sit for the patent bar. So you have to be knowledgeable. It's the way that they get knowledgeable people in their subject matter to become patent attorneys. So
there's a lot of these ads on TV, and the impression, and also on other legal document services on the internet. There's this impression that if I just simply did it myself, I can get it filed, and then if somebody goes and reproduces the same thing, I can assert my rights. Is that true?
It's probably a very, very small minority of people who use those self-help services who actually receive patents. It's a very difficult process to get your patent through the Patent and Trademark Office. It's really an adversarial process between the filer and the Patent and Trademark Office. So, when I said that only patent attorneys can file patents, inventors can file them on their own, like you're suggesting with these self-help services. But it's probably less than 1% that are ever successful doing it themselves. Inventors are bright, intelligent people, but they're not well versed in patent law.
So, one of the things that people wonder about is where do you spend your time if you're a company and you have somebody on staff? Are you going to spend your time through the frustration versus having someone who is versed in and admitted to that bar and understands what those patent examiners are going to argue about and what they're looking for? So roughly, what is the process that you would take and say, we'll use our hearing aid example, and we'll say that, let's say that it's not software. Let's say that it's designed in a certain way to be comfortable, and inside is some sort of mechanical device that would make hearing at a certain decibel easier and more accurate and more clear than other hearing aids. What would be involved from the patent attorney side once the client presents the object of the device to you, and how long would it take?
Sure. I mean, that's a great example to go through. Everybody can understand it at a high level anyway. So the inventor would give me all the information about how the device works and what makes it better than what's already out there, what we call the prior art. And so once I get that information, I can do a patent search to see if there's anything that would prevent my client, the inventor, from getting a patent. But absent anything that's blocking him, then I would write the patent application, and it's not a fill-in-the-blank kind of form. I always say it's like a legal brief, right? We're making our case to the Patent Trademark Office why this device is entitled to a patent and why my client is worthy of a legal monopoly for the 20 years after we file the patent. And so I file the patent, the legal brief, if you will, and it gets accepted and examined by the Patent Trademark Office. And the Patent Trademark Office will come back with any issues with the patent from a formality standpoint, as well as arguments about why the prior art may be a problem, why this may not be unique in the whatever area of the art, the hearing aid art. And then there would be a back and forth process where I would make our arguments, again, a legal brief, making our arguments about why we deserve this right. And then the process, it's quite a long process. It takes about 3 years from the time you file a patent till it issues, if it issues. But the important thing there is that you get your filing date, right? So you and I have talked about this before. It's a first to file country. The United States is first to file country. So it's not the person who invents it first, it's the person who files first who gets the patent. So the filing date is the most important thing. And it starts that 3-year clock as well. So the longer you push that off, the longer you push off filing, the longer you push off actually receiving your patent.
So once you file, though, you have a provisional patent, or is that right?
Yeah. So you can file a provisional patent. Provisional patents typically take less time. They're less difficult to prepare. They don't actually need claims, for instance. And they're much less expensive from a patent trademark fees standpoint. There are fees associated with patents that are both attorney's fees and fees that you have to pay to the U.S. Patent Trademark Office. So a provisional patent, you can get your filing date early. It's usually cheaper attorney's fees, and it's always cheaper USPTO fees. But if you file a provisional, you have 12 months to file a non-provisional, right? So it gets you your filing date, and then 12 months later, you have to file a non-provisional. The provisional never gets looked at by the Patent Trademark Office, but it gets you your filing date. And then you file your non-provisional patent claiming priority back. So anybody who filed back that year, anybody who filed in between the filing of your provisional and your non-provisional is closed out from getting the patent ahead of you.
So I think from the point of view of expense, and so if you have a series of devices and that you're manufacturing things that go into the stream of commerce that you want to protect, you want to do it as soon as possible, perhaps file a provisional patent while you're getting ready to apply for your patent, and I'm working through that process with that, and by doing that, you have a 20-year monopoly on that particular use.
So yes, that's exactly right. The monopoly, what it covers is it allows the patent holder to prevent others from making, using, or selling the device, right? Once you've obtained that patent.
So if you have a good candidate, so I'm just listening to it from a business point of view, and I say I am a latecomer to the device manufacturing area, and I have say an advantage, something I have advantage because it's a new way of looking at maybe by hearing a device. I'm not an audiologist, but we're just using that as an example. And then we have Old Blue here, the way hearing devices have always been made, and I don't want. I want them to stay at a disadvantage, and I want to be advantage. I want to be nimble. I would want to file that provisional patent and start that process as soon as possible, right? So would that be right?
That would absolutely be right. The other thing is that you have to file your patent before you sell your device, right? So you need to lock in the protection before you sell, and so the other advantage you get from filing that provisional is now you can say patent pending, right? It gives your competitors pause on following you in that technology because they don't know exactly what it is you're patenting, okay? Which brings up another timing issue. Your patent won't publish, the public won't get to look at your patent for 18 months after filing. So you have 18 months of head start before your competitors even know which direction you're heading in. So yeah, you want to be nimble, right? So you file and you take off, developing and starting to sell your device, and you have 18 months where it's kept secret from the public.
So when is the best time to consult with, the legal aspects of the intellectual property? Is it at the beta phase? Is it at the development phase? When in the cycle of development does a patent attorney come into the picture?
I think, that's a great question, and it probably depends technology and the particular company, but it's probably when you think you've got it figured out, right? So when you're talking about beta testing, right? Okay, so we just need to change this one aspect of this hearing aid, and we're going to be able to get a wider range of sound, right? And we know how to do that. We haven't done it yet, but we know how to do it. One of the things about a patent is you don't have to actually have built the device to file for a patent. You just have to be able to explain to somebody in the patent how to copy it, how to make it, right? You have to disclose that in the patent. And so when you've got it figured out, that's the time when you want to start filing for a patent, start getting the legal advice. And certainly you want to do it early enough on that you don't prevent yourself from being able to file for a patent. And like we discussed, you got to do it before you sell the device, but you also have to do it before, if you've disclosed it, if you've gone to say
Right.
presented it on a webinar or at a meeting,
Yeah,
and you've
on one of
these,
venture forums. You start showing it up at the venture forum. I'm sorry, you've already given somebody else.
Right. So,
Right.
But you have 1 year from the time you disclosed it. If you, as the inventor, disclosed it, you have 1 year to file, but you have to file a non-provisional within that year. Okay. And so, but one of the things that you just tipped off was that if you did present it at one of these venture things and somebody else tried to file the patent on it, right? Number one, they shouldn't, but number two, they are not the inventor, right? And you have to, under penalty of perjury, say that you were the inventor when you file for this patent. So it happens, and you really want to prevent it from happening. So you want to be able to, I always tell my clients, I can file a patent for you before you talk to that company, before you present at this forum, whatever it's going to be. I can file your patent before that, and then you have no worries of any of that stuff.
Well, thank you very much. And I think we're going to continue this conversation about patents before we go to other places about alternative to patents. So thank you very much, Matt.
Sure. Yeah, Sylvia, thank you.
Oh, wait, by the way, lovely picture behind you.
Oh, thanks. It's Yosemite Falls. I actually took that with my iPhone last year.
Did you copyright that?
We'll get to that.
Thanks.
But yes.
Bye.